As we gather here today, we stand at a pivotal moment in the legal landscape of our region. The concept of ADR, encompassing methods such as mediation, arbitration, and negotiation, that has gained significant traction globally as an effective means to resolve the disputes outside of the traditional court system. These mechanisms often offer numerous benefits, including faster resolution, reduced costs, and offer more satisfactory outcomes for all the parties involved. Whenever there is a disagreement, and disagreements happen in day in, day out in our lives, disagreements may be between parents and the children, disagreement may be between wife and husband, disagreement may be are in home, outside in the market, and wherever there is a disagreement between the two persons, it ultimately we call it as dispute. That the two do not agree to one point, and then we call it a dispute. And then we have so many mechanisms. Like litigation is one where we go to courts, and establishment of the training and a cadre of skilled mediators, which needs. I mean, wherever you open a center, you need to have basically trained skilled mediators, arbitrators and negotiators who understand the local, in local context, who understand that how the disputes are to be resolved outside the court system. I wish to involve our scholars and students. Even BCI, will agree with me that BCI has prescribed it as a mandatory curriculum component to prepare the next generation of the legal professionals. And then another aspect is that raising public awareness about the benefits and availability of the ADR options. As we embark upon this journey, we must remain cognizant of the unique socio-cultural fabric of Jammu and Kashmir. Our ADR mechanism should be designed to respect and incorporate local customs and traditions while adhering to the principles of justice and fairness. Furthermore, the institutionalization of ADR in our region is not just about easing the judicial backlog which we have. Nevertheless, honorable dignitaries, delegates, scholars and students, it's about empowering those citizens with choices in resolving their disputes. With these words, I welcome you all, and I hope that the deliberations and the conclusions would take us to a result-oriented approach towards the ADR dispute resolution system in the end. I hope, I wish you all the best. I wish this seminar all the best.
As a lawyer, we can think about anything about ADRs. Suna hai, samajhte hain, ADRs. Whether it is a new concept for us? No. This is a much prior to our, we can say so, in the ground root level, we are adopting this practice and we are doing this practice, whether it is a panchayat system or any other system. The topic is today is a institutionalization. How to institutionalization this thing? Supreme Court is working very hard on it. They are creating ADR centers. They are much working on the arbitrations. They are doing everything. But are we prepared for this mechanism? Somehow, as a lawyer, I feel, agar ye dispute bahut jaldi resolve ho gaya, then what we will do? The answer is, it is always a win-win situation for the country, for the lawyers, and as well as for the judiciary also. Why so? Why so? It is for the lawyers. We'll have to make them understand to the clients that the time is money. We'll have to save our time. Time is more important. If you resolve your dispute within 10 days, why you have to wait for the 10 years? This is the beauty of ADRs. So don't hesitate for going in an ADR system. It is always good. And last but not the least, I will say only this thing. The Bar Council is not silent on this thing. The Bar Council has given the proper curriculum for the students to understand the concept of the ADR and how to do it. So be focused on the ADR because the future is ADR.
The need for a well-integrated framework for ADR in Jammu and Kashmir is not merely administrative. It is in essence constitutional, jurisprudential, and socio-legal. Our constitution promises justice, social, economic, and political, and the promise is best fulfilled not only through the traditional court system but also through accessible, efficient, and participatory mechanism of dispute resolutions. As you are all aware, the Indian Arbitration and Conciliation Act 1996, modeled on the unilateral model law, laid down the modern legislative framework or arbitration and conciliation in India. It was designed to bring Indian arbitration law in harmony with global standards, ensuring neutrality, party autonomy, minimal court intervention, and enforceability. However, mere legislation without institutional and cultural acceptance is like a library without readers. The potential remains dormant. To harness this potential accessibility in regions like Jammu and Kashmir, where the topography, socio-political dynamics, and economic aspirations are distinct, we need to institutionalize ADR both structurally and educationally. This means creating permanent ADR centers, integrating ADR practices into governmental and commercial contexts, building awareness among citizens, and importantly, preparing our young legal minds to engage the ADR not as an alternative but as a primary effective mechanism for justice. The role of law schools like yours becomes paramount in this vision. The Bar Council of India, recognizing this paradigm shift, has already incorporated alternative dispute resolution as a compulsory paper in the curriculum of LLB course through its legal education route 2008. This was a prescient move, and then it was evident that ADR should shape the future of dispute resolution in India. But the evolution did not stop here. With the growing emphasis on collaborative and consequential resolution of disputes, the BCI later recommended the inclusion of mediation as a separate subject, recognizing its distinct philosophy and expanding relevance. The Supreme Court and various high courts have established mediation centers within court complexes, and guidelines are being laid down to ensure quality training and accountability of mediators. Jammu and Kashmir too must have proactively in this direction within the enactment of the Mediation Act 2023, now applicable to the Union Territory, to stage each set forth established set of state and district level mediation councils, accreditations, and mediators, and formulation of rules that should adhere. This is a golden opportunity for the legal fraternity of Kashmir, not only again assign the national standard, but to innovate and adapt to the region like unique needs.
When we really understand by exercising, by using this, the Bar Council of India, we were opposing it at that time. Today, Bar Council of India, under the leadership of Mr. Manan Kumar Mishra, Dr. Apurva Sharma, Vaidyaji, they have included in the curriculum. And it is very difficult job for the leaders like us. Now, earlier we were thinking the lawyers will be losing the job. Today, lawyers are getting income 2 times. They are taking fees as a counsel in the case, and when they appear in the mediation, that time also they charge. And not only this, earlier we were thinking that the whole benefit will go to the retired judges, retired officers. But today I am happy the Supreme Court, our legal aid committees throughout India at national level, state level, district level, they are appointing our lawyers to act as mediators. So my lawyers are acting as mediator, they are also being paid. And they are acting as a judge. Earlier, lawyer job was only to plead before the courts. Today, with this system, my lawyers have also become the judges. The clients, they bow down before them. Even their colleagues, lawyers who are representing the parties, they also bow down before. And we face a difficulty. We are getting so much request from our members of the bar to kindly get us included our name in mediation. We face so much, because there are limited facilities to give training, and so much pressure. For last year when I was the president, we recommended the names of 300 lawyers for training to act as mediator. Now, under the leadership of Mr. Kapil Sibal today, same number of lawyers' requests have gone to Supreme Court. Likewise in every high court. So, the system of mediation, qua lawyers, it is very good. But qua litigants, I'm sorry to say, it is not good. They have to pay. But from one aspect, that if the matter is settled at district level itself, the litigants are not supposed to go to High Court and Supreme Court. That become the final. Because in mediation, when we agree to any terms and conditions, there is no provision of going in appeal. Both parties are ultimately satisfied.
ADR is not a new concept. ADR has been there from times immemorial. What is ADR? ADR is resolving disputes without a trial. ADR is like we have Lok Adalats. Lok Adalats also, we come on the table, people settle their disputes and they go happy without facing the rigor of long drawn trials. Much can be said about ADR. And ADR should be accepted as a recourse to quick disposal of disputes. We crave and wish that the blessings of Almighty be with all of us. With the faculty of law, this whole university, I think it is more than now 30 years I have left this institution. The fragrance of this institution is same. I have gone back to 3 decades, but as if I am just a student. And my great respects to Dr. Nilofer, the present Vice Chancellor, who has given the sheen, the glare, and the aroma to this university. Universities are always there. You have every university, you have blah blah, so many universities. But I am proud of my university. University of Kashmir. And I would like to thank Dr. Karan Singh, who so many years back gave 1,000 canals of land for establishment of this prestigious institution. All the best. And my great thanks to Dr. Koteswar and Mrs. Koteswar to have joined us here in view of their lot of busy schedule. Once again, I would like to thank all of you, the love, the affection you have all given us. I would like to thank you once again.
Being in the administration, I know sometimes how much as an institution we suffer when the cases are delayed, and it affects the working of the institution in a very long way, and it really makes us handcuffed to take any decision. As we understand that our region with its unique socio-cultural context faces challenges in the timely and effective resolution of disputes, which often leads to prolonged litigation. The institutionalization of ADR mechanism, I believe, can serve as a transformative tool to address these issues, fostering development in the region. I am sure that it will help in reduction in pendency of cases because the judicial system in Jammu and Kashmir is overburdened. So ADR mechanism is one of the alternatives for this, where the mediation, conciliation and arbitration can significantly reduce this burden by resolving disputes outside the traditional court system. It is also cost-effective and time-efficient alternative to litigation, making justice accessible to all sections of society, including marginalized communities and women especially. Given the diverse cultural and religious fabric of Jammu and Kashmir, ADR can play a pivotal role in resolving disputes amicably, thereby promoting social cohesion. Mechanism can empower local communities by involving them in the resolution process. As we see that the global and national trends are attractive in a sense that ADR is increasingly being recognized globally as an effective tool for dispute resolution. ADR in Jammu and Kashmir will align the region with national and international best practices. Our School of Law, University of Kashmir, proposes to come up with the framework for its institutionalization by setting up dedicated ADR centers at the district and tehsil levels and act as catalyst to provide accessible and efficient dispute resolution services. It can also conduct training programs for mediators, arbitrators, and conciliators on regular basis, and university will support this endeavor to ensure a pool of skilled professionals capable of handling diverse disputes. We can also launch public awareness campaigns to educate citizens about the benefits of ADR and encourage its use as a primary mode of dispute resolution. Your Lordship, with your support, our university can integrate with judiciary by establishing a seamless integration between ADR mechanisms, the formal judicial system, and services of our law faculty, teachers, and budding law scholars by allowing for referrals and appeals where necessary. I am sure that by such a plan, there shall be reduction in the backlog of cases in courts to great extent, ensuring enhanced access to justice for all citizens. Provision of economic benefits through reduced litigation costs and faster dispute resolution, and more importantly, it will cater to the idea of establishment of Jammu and Kashmir as a model for ADR implementation in our country. At last, but not the least, I am keen to see that the institutionalization of ADR mechanism in Jammu and Kashmir is not just a legal reform, but a step towards building a more inclusive and prosperous society, and our School of Law must take the necessary steps to make ADR a cornerstone of the region's justice system.
What is this alternative dispute resolution? It is not unique or confined to the legal profession. As just mentioned by the Vice Chancellor also, there is huge pendency in the courts which is causing delay in getting justice. Various methods have been thought over by the Law Commission, judiciary also from time to time, how to overcome this problem of huge pendency in courts. As we all know, justice delayed is justice denied. Often, many of the cases lingering for years together are not decided in time. Therefore, this mechanism has been evolved. Now, it has not only a mechanism, but it has got a legal sanction. behind it. How to resolve the dispute in an amicable manner. Through mediation, there are various kinds of alternative dispute resolution. What are those? What we find, many of you must have heard of Lok Adalat. There is also new scheme, there is an act called the Mediation Act of 1924, which is now it has institutionalized the mechanism of mediation. And this mediation is not the prerogative of the judiciary. Madam has been also mentioning about this community mediation. In fact, it finds a specific chapter in the Mediation Act. In Chapter 10 of this Act, which provides that any dispute likely to affect peace, harmony and tranquility amongst the residents or families of any area or locality may be settled through community mediation with prior mutual consent of the parties to the dispute. Who shall be the mediator? The mediator can be a panel of 3 at least minimum. And they need not be lawyers or judges, as we generally happens in case of mediation. Who can be the persons, as the Act itself provides? A person of standing and integrity who are respected in the community. Any local person whose contribution to the society has been recognized. Representative of area or resident welfare association. Persons having experience in the field of mediation, and any other person deemed appropriate. So what it provides is the participation of the community, not necessarily from the legal profession. That's why it is important that whether you are a lawyer or belong to legal fraternity will not come in the way if you are having the standing in the society, whose words and advices are valued at a society, who can resolve many of the disputes which we find stuck in the courts. This is a new area. And in the normal statutes also, there is a provision for mediation, conciliation, or arbitration. These are all methods. Because you see, whenever a matter is brought to the court, it has to be resolved through the process mentioned in the procedures provided in the Act. The lawyers have to follow the procedures, judges have to decide the case based on the procedures laid down. Thereby, many of these important aspects, time is consumed in resolving through these mandatory procedures. This is one aspect when mediation, any other alternative dispute resolution mechanism is invoked, then these procedures of law of evidence, or for the matter, law of CRPC, CPC, they can be waived. But there must be willingness on both the parties for a settlement through mediation. So these are important strides, development in the Indian law legal system, where we are trying to resolve disputes out of the court. It is very important. Many people do not know. Whenever we have a problem, we immediately rush to the court. We engage a lawyer and we get stuck in the process. Therefore, it is very important that these progressive provisions of the Act, new developments in the Act, for helping resolve disputes are made known to the public. Who is best suited to do that? Obviously, the legal profession, lawyers and the students of law also. But students of law said, we are students of law, how do we do this? You may wonder, yes. Have you heard of National Legal Service Authorities Act? Legal Service Authorities Act. And there is a provision for legal aid clinics. I am sure that law department must be having a legal aid clinic. In that you get involved and you are classified as paralegal volunteers. As paralegal volunteers, you not only enrich your knowledge of the problem faced in the society, but also impart knowledge of the law, relevant laws of the land, making them people aware. See, making people aware of the rights and duties, laws of the land, is a very empowering and very critical aspect of any society. A society full of aware citizens certainly will have a better system, more peaceful society, more progressive society. A society where people, citizens are not aware of the rights and privileges and duties would have more problems. There, the role of the students also come in a very important manner. Your talents would show. Your perseverance, your talents will speak out. This is a profession where you are known by your word of mouth. You must have seen the students of law that lawyers, we cannot advertise ourselves. That is not part of this, against the code of conduct of the lawyers. You cannot say, I am so-and-so lawyer specialist, I charge list fees, and I am the best lawyer. You can't say that. But how do the people come to know? By word of mouth. People will ask, just like doctors. Whenever you suffer from some ailments, even if your brother or sister or father is a doctor, you may certainly consult, but again you will still ask, who is the best doctor in this field? And you will go accordingly, in spite of your friends or relatives being a doctor themselves. Similarly is also in this profession. Your performance in the court, your dedication in the court, your focus of your profession will ultimately pay off. The gestation period is long. Therefore, I would advise those law students who aspire to become lawyers not to get disappointed. There are many first generation lawyers who had struggled hard. For years they never got any client or fees. But their dedication, their sincerity paid off and is bound to reflect. Your merit is bound to be recognized by your colleagues, by the judges, by the society. Therefore, I would request that it is a challenging and there is no shortcut to success. What I would say is that your professionalism, your sincerity, your focus will ultimately, your dedication will pay off in the long run.